Okay. All
yeah,
right. Okay.
you can share
Thank you
your
very
screen.
much. I want to first and foremost thank Professor Bright Bazuaye, the Dean of the Faculty of Law, University of Benin, for inviting me to present this talk. And of course, I want to thank Professor Amos, the Director of the Center for Community and Oceanic Law, for inviting me. It's such a pleasure. And I want to thank everyone who has connected, distinguished colleagues from the great Faculty of Law, University of Benin. I will soon say in a moment why, of course, I mean, acknowledge the greatness of the Faculty of Law of the University of Benin and all our students who have connected even for this presentation. I'm particularly grateful to have this opportunity to present because I actually studied at the Faculty of Law, University of Benin, a long time ago. And I have very fond memories of my time in the University of Benin. I mean, one of the things that I'm ever so grateful to the Faculty of Law of the University of Benin for is that I believe it's still the same, but I don't know if it has changed. While I was there, we had the privilege, the unique privilege of being the only faculty of law all over Nigeria that had public international law as a compulsory course that we did. And I'm very grateful for that opportunity because, of course, I mean, now in terms of my career, in terms of my teaching, my research, and even the policy work I do, I mean, like it's based on public international law. So thank you so much for sort of starting me off on what I'm doing now, and I'm really, really thankful for that. If I could share my screen, I'll just quickly do that to try and get my presentation. Let's see if I can get that. Let's see. I'll just try and see if I can get to it. Okay. Right. Try and see if I can get to my slides. Let's see. That will work. No, this is not what I want. Okay. Please bear with me. I'll just try and get to my slides. And let me see. Just open it up. Okay. 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 I wonder if we can all see the slides. Can we see the slides, please?
Yes,
Yes,
Prof.
we can.
Fantastic. Fantastic. Thank you very much. So the topic I've been given to talk about even today is on Africa and deep seabed mining, strategic abstention from sponsoring activities in the area or missed opportunity. And I'm currently, apart from being a professor of international law and international relations at the Cardiff University School of Law and Politics, I'm also honored to be a member and currently the vice chair of the Legal and Technical Commission of the International Seabed Authority. So I'm afraid I'm required to always make this disclaimer at the beginning of every presentation I have to make that is connected to the International Seabed Authority. So I just want to say quickly, the views expressed, the designations employed, as well as the content and materials I'm using do not imply the expression of any opinion whatsoever on the part of the Legal and Technical Commission or the Secretariat of the International Seabed Authority. In other words, everything I'll talk about here is strictly my expert view as an individual, so I'm not representing here the Legal and Technical Commission or the Secretariat of the International Seabed Authority. What I'm hoping I can cover in the next 35 minutes or so that we can have an opportunity for questions and answers. I would give an introduction, trying to give an idea of, looking at the oceans. We want to understand the different principles that govern the ocean, and then we would zero in on what is sometimes called the common heritage of humankind, but in the relevant treaties, it is identified as the common heritage of mankind. So you'll find I might use it interchangeably. And most times I probably would just say CHM just to have a short form for that. And then I will talk about why is there an interest in the area, because the area is the part of the sea that is governed by this whole concept of the common heritage of humankind. And after that, we'll just look at some instruments that Africa has adopted over the years that shows that there's a direction of travel in terms of Africa, that there's a need actually to get more involved in terms of the whole regime. Right now, Africa participates obviously as part of the discussions. We're a state party to the relevant treaties. We're members of the International Seabed Authority. I'll talk a bit more in terms of that as we go on. And also, I mean, like we've made a lot of inroads in terms of the African Regional Group, in terms of putting forward proposals that have been moved forward. But we'll see as we go on that in spite of all these instruments, Africa has not yet sponsored an entity to actually get involved in deep seabed mining. And so I'll come from looking at the African instruments on deep seabed mining to look at the particular topic I've been given, to give my views in terms of this, whether the whole idea of Africa being missing from deep seabed mining in terms of sponsoring a contractor. Is there an aspect that we can argue there is a strategic abstention, or do we think is a missed opportunity? So I'll give some ideas that I have in terms of that, because I've done quite a bit of work in terms of that. I've written a book in terms of that. I've written lots of research papers, and I've also been involved in quite a number of policy work. And my view, as you would see as we go on, I'll make full disclosure. My view is that Africa is missing an opportunity here, and I'll give my reasons. And then I'll conclude with some things that have been done in some very important platforms pushing for Africa to at least join the rest of the world, the other regional groupings, in sponsoring an entity to get involved in deep seabed mining. So let's start off with just having a general overview of the principles that govern the seas, so that we understand what we mean by the area, what we mean by the concept of the common heritage of humankind. So there are three key principles that governs the sea. When we talk about the law of the sea, over the years, I mean, the law of the sea is one of the oldest area of public international law. And over the years, these principles have been developed. We have the principle of sovereignty. And when we look at the whole idea of sovereignty, we find out that when we think about the land territory, as we talk about the land territory, we're talking about the concept of sovereignty. As we move from the land territory towards the sea, we have a part of the sea called the territorial sea. I've given the diagram that will probably explain a bit more to those of us who are not familiar with the law of the sea. We have the territorial sea, which is 12 nautical miles from the baseline of the land territory, and basically you have sovereignty in that part of the sea, and the sovereignty even extends beyond the waters to the airspace. The only exception in terms of that is what we call innocent passage. Ships can navigate if their passage is innocent. But we'll see that as we go further away from the land territories, as if the idea of the rights of the coastal states starts to minimize. When we move from the territorial sea, we have another part of the sea called the continental shelf, which consists of the seabed and subsoil, even under after the territorial sea. And then you have the exclusive economic zone. Sometimes these two overlap, though the continental shelf can be extended beyond 200 nautical miles, which is the full extent of the exclusive economic zone. But that involves a complex process of having to make submissions to a commission, a UN commission, on the limits of continental shelf. So going beyond the continental shelf and the exclusive economic zone, we have the high seas. That's the water column that is beyond national jurisdiction. But under the high seas, we have the area, the subsoil. And this area, and that is what I'm going to be talking about, is administered by a body called the International Seabed Authority that has been established under the United Nations Convention on the Law of the Sea. And it has powers mainly in respect of mineral resources. Maybe if we have time to talk a bit about it, some might be interested in terms of there's a new treaty, there's an implementation agreement that deals with even non-mineral resources in the area and in the high seas. The BBNJ agreement, we probably have heard about it, or some will call it the high seas treaty. So that's the idea of this. The area we're interested in, or the part of the sea, rather, that we're interested in is the part that is called the area beyond national jurisdiction. And that's what the focus will be all about. This area is subject to a very complex concept called the common heritage of, as I said, in the treaty, it's called the common heritage of mankind. But in recent times, I mean, like most people talk about it as the common heritage of humankind. And I have two quotes even there. One of the quotes is from a scholar called Basler. He tries to explain the complexity of this concept of common heritage of mankind. He said, when we think about it, we shouldn't think about it as an individual rule. There is a bundle of rules and principles, and it covers quite a bit. And we'll see in a minute when I move on to the next slide, different aspects of this concept of common heritage of humankind. I wrote something in 2011. I also pointed to the fact that sometimes it can be a bit nebulous because it has so much packaged in this concept that sometimes it's open to a diverse interpretation as to its exact scope. But over the years, as we've had treaties like the United Nations Convention on the Law of the Sea, as modified by an implementation agreement in 1994, implementation agreement, we've seen some clarity about some aspects of this principle that we can identify directly. And so some of these principles were put together even before the UNCLOS, the United Nations Convention, was adopted. In 1967, a diplomat, Avid Pardo, he was a Maltese diplomat. A Maltese diplomat. He came before the United Nations General Assembly and made a powerful speech. And the essence of the speech was that he was saying that there's this part of the sea, the seabed subsoil beyond national jurisdiction, that it would be dangerous to allow any big nation to just come and appropriate every part of that sea, because he identified from his research that there were rich mineral resources even in that part of the sea. So he called for the international community in a speech before the General Assembly in 1967 to declare that part of the sea to be the common heritage of mankind. He said at that time, as I said, now would say common heritage of humankind. And the whole idea is that he proposed that there had to be some kind of governance mechanism that would sort of control that area, manage the area for the whole of mankind. He advocated equitable sharing of resources, even right in that area, giving particular preference to developing states. And he zeroed in on what has become an essential part of the common heritage of humankind and the whole regime governing the area, he zeroed in that we shouldn't forget that there's a need to ensure that there's a balance. While we want to go in and encourage people under the regime to be able to go in with the permission of whatever international machinery they set up to go into explore and exploit and carry out deep seabed mining activities there. He balanced it, and that is a crucial point that I want us to hold on to. He balanced it with the fact that we also have to be very interested in putting together the appropriate mechanism to ensure that we are protecting also the marine environment from potential harm during mining activities of the seabed. And then he zeroed in and said, everything we do there, it should be meant to be for peaceful purposes. And this speech he gave basically triggered off something in terms of the United Nations and the international community generally. And this led to various meetings that eventually led to the convening of the United Nations Conference, the third United Nations Conference on the Law of the Sea. And one of the central parts of discussion at that conference was, what do we do about this part of the sea that we've agreed to, that it should be the common heritage of humankind? And after a whole range of negotiations, and interestingly, Africa was very, very active in terms of these negotiations. The OAU at that time, before it was replaced by the African Union, put together a declaration in 1974 to sort of bring together African states and have a common position. And in that declaration, one of the crucial things that was brought out was that the deep seabed area beyond national jurisdiction should be the common heritage. At that time, they said mankind, humankind, if we want to use the modern parlance that people use, and that the machinery should be put together. So Africa has always been on board in terms of the deep seabed area beyond national jurisdiction being the common heritage of mankind. And of course, eventually, after a lot of negotiations, compromises here and there, eventually the United Nations Convention on the Law of the Sea was adopted in 1982 at Montego Bay, Jamaica. And this convention was a very, very important convention. It covered a whole range of issues affecting the sea. And one of the aspects that it went into and discussed and developed was the deep seabed area beyond national jurisdiction. So part 11 of that convention, the UNCLOS, I'll use the short form, the UNCLOS, basically talked about the concept of the common heritage of humankind, mentioned as common heritage of mankind in the convention, and what is meant to be all about. Subsequently, the part 11, because it was a bit controversial, some developed states were not happy about some provisions. Some even said it was sort of like international socialism. The United States was at the forefront of that. They insisted they weren't going to ratify the convention. So in 1994, an implementation agreement was adopted which modified some parts of the part 11 of the UNCLOS, but it did not take out the concept of the common heritage of humankind. So when we look at this convention as modified by the 1994 agreement and various regulations that have been adopted by the International Seabed Authority, some things that are clear is that the area with a capital A, because that's what is normally called, it means the seabed and ocean floor and subsoil, they are beyond the limits of national jurisdiction. So it doesn't fall within national jurisdiction, it's outside national jurisdiction. Remember the diagram we put up there, the high seas with the water column, and right under is the area, the seabed and ocean floor. And it was very clear that the focus of part 11, and that's why the BBNJ had to be adopted, because there was a gap in terms of this. The focus was that the resources that would be dealt with by Part 11 were meant to be resources in terms of mineral resources. And this provision in terms of the common heritage of mankind or humankind is so important that even the UNCLOS said that no state party should enter into any agreement whatsoever to derogate from the principle or the concept of the common heritage of mankind. So these are some things that we can pull out from as being some common characteristics of the common heritage of humankind. The area, and not only the area, the resources, that's mineral resources that are found in there, are meant to, under Part 11 of the UNCLOS as modified by the 1994 agreement, be the common heritage of mankind. So the idea is also under those provisions that no state can unilaterally go in and appropriate the area and the resources in the area, the mineral resources. I'm sure some of us will probably have heard about what has been happening recently in terms of the United States of America. The United States of America is not a party to UNCLOS, and the United States of America, since the second time that President Trump has come in, has basically argued that because they're not a party to the UNCLOS, they're not bound by all this provision. So the President of America, President Trump, has issued a memorandum stating that the United States of America can unilaterally go into the area and they can authorize contractors unilaterally to go there and carry out deep seabed mining activities. I have my views, my strong views on that. I agree that the United States of America is not yet a party to the UNCLOS. But when we look at the provisions of the common heritage of mankind, my argument, and I think is backed by various things to support that and the decisions of the International Court of Justice, is that the whole concept of the area being a common heritage of humankind is not only a treaty obligation, but it has since over the years, with the number of states that have adopted the UNCLOS, a number of states that have even carried out even the practice of understanding that is the common heritage of humankind, including even the United States of America, in my view, that it has become customary international law. And because of that, even if the United States of America is not bound by UNCLOS as a treaty obligation, it is bound under customary international law to ensure that it doesn't encourage entities to go there unilaterally to exploit these mineral resources. But there's still discussions in terms of this, and we'll see how it pans out. But apart from just organizing the exploitation of that part of the sea, one of the things that is very crucial in terms of the common heritage of mankind, which is really important as we're talking about Africa, is the understanding that the common heritage of mankind is to be for the benefit of all humankind. But there's always an emphasis that there should be particular consideration given to the interests and needs of developing states. And so you'd find out that even as the regime has been developed, as various regulations are being put in place, the idea is also to encourage developing states not to just stand back and just be spectators, but to actually get involved, because there are benefits involved in being a direct participant of this whole idea of the area being the common heritage of humankind. Of course, the convention talks about it, that there's a need that we understand is meant for peaceful purposes and not meant for military activities, really. It also encourages marine scientific research there to be carried out for peaceful purposes for the benefit of mankind as a whole, or humankind as a whole. And the idea of this is when marine scientific research is carried out, is meant to be shared with everyone, including developing states. Then a crucial part of this, because the idea is for there to be a balance. While there's the idea of going in there to exploit eventually, the idea is that even as we're doing it, we must always ensure that we are putting in place robust rules to ensure that It's not a free-for-all thing that anyone just goes in there, but that they must do it in a way that there are rules to protect the environment. And that's why over the years, what has happened is that the International Seabed Authority has not been in a hurry. They've been taking things step by step to ensure that for exploitation, because right now what is going on is entities have contracts for exploration. The exploitation stage, we've not got there yet. What they've been doing is to try and develop an exploitation regulation. And one of the crucial things that is at the foremost of everybody, all the state parties, and that's what the discussions are all about, even NGOs and different groups, is to ensure that the important mechanisms that are put in the exploitation regulation that would ensure as much as possible the protection of the marine environment from seabed, deep seabed activities. And it also talks about protection of human life, even in the whole provision. So people don't go in there and be ignorant of the fact that also human life is really important as we carry out these activities. And it calls for the establishment of a strong institutional mechanism or machinery. And we see that that's the International Seabed Authority that has been put in place. This part 11, as I mentioned earlier, there have been some changes, major changes by the 1994 implementing agreement or implementation agreement. There's a change in terms of a body called the Enterprise. The idea was for it to be an international mining entity of the International Seabed Authority. But the agreement said, well, no, we will not start that immediately. First, this body will start off as part of the secretariat. Then, as things start to become clear, then it will start to move towards being an autonomous body. There were changes in terms of transfer of technology and some very important aspects. But I want to emphasize that the whole idea that the area is the common heritage of humankind wasn't changed by the 1994 agreement. The International Seabed Authority, Professor Amos, the center is an observer there. It's an independent organization. It's not part of the UN, though it's part of the UN family. It was established by the UNCLOS as an independent, autonomous organization, given a specific mandate. There have been modifications here and there by the 1994 agreement, but in essence, it's an independent, autonomous organization. Its remit is to organize, control all mineral resources related activities in the area for the benefit of humankind as a whole. It has the important mandate. I cannot emphasize this enough because sometimes, there are some people who, as they're talking about this, they tend to forget that that is a crucial part of the ISA's mandate. And that's why the ISA is involved in a whole range of things right now to ensure that whatever is done in terms of activities in the area, that is done with the understanding that it has to be done in a balanced way to ensure that the marine environment, as much as possible, is protected from any deep seabed related activity. Quickly, I'll just touch on this. Why is there an interest? There's so much interest right now in terms of the area. The reason for this is that over the years, we're seeing with the transition away from, a fossil fuel based economy to a clean energy type economy, there's so much interest in getting critical minerals. And the feeling, the discussion out there is that the amount of critical minerals that would get on land would not be enough to cover important aspects of this transition to a clean energy economy. If we're going to be talking about EVs, electric vehicles, we need these critical minerals. If we look at our mobile phones as they get more and more sophisticated, we need these critical minerals. If we're talking about solar panels and things like that, we need this critical mineral. And that's why there's more and more interest in terms of whether or not the area is an alternative, area or an alternative part where we can go in and get these critical minerals to help in terms of this transition to a clean energy economy. And what has happened over the years is that Africa initially, after the UNCLOS, the discussion, the development of the rules, for a while it has seemed Africa stood back and wasn't directly participating. But in recent times, there appears to be a shift. We're seeing in terms of some documents from the African continent, from our continent, Africa, that is getting to understand that deep seabed mining might just be something that we cannot ignore. This is especially so when we're talking about the African blue economy. We know the African blue economy covers a whole range of areas, but we're finding out that there are documents now showing that, well, we might consider deep seabed mining as an aspect of the African blue economy. The Agenda 2063, some of us will be familiar with it, is a strategic framework, put together by the African Union to govern, it was adopted in 2015 to govern socio-economic transformation over 50 years. And one of the things that this agenda does, it picks up, it has 7 aspirations, but in aspiration 1, it refers to the whole idea of deep seabed mining. In aspiration 7, it says we cannot stand back and miss out on our rightful share of global commons. The area is one of the global commons that we have, and the need to be active and equal participant in global affairs, especially in multilateral institutions such as the ISA, so that we were able to at least participate and be part of what is happening in terms of other regions of the world. In 2019, the African Union went ahead to adopt an African Blue Economy strategy. And one of the things included in the strategy is the understanding that there's a possibility that one of the new frontiers that we might want to consider and start to work towards as Africa is the whole idea of deep seabed mining. Remember, as I said, everything now is at the exploration stage, but we are getting closer and closer to the possibility that we might move to exploitation. The exploitation regulation is being worked on at the International Seabed Authority. Professor Amos had mentioned it was at the council meeting, and everybody's calling for a speeding up of that so that things are clear, so that we know that there's going to be a balanced approach. Yes, deep seabed mining, but we put in effective mechanism to ensure that it's not a free for all, that appropriate things are done by those who will go in to ensure that they're minimizing the risk of damage to the environment. So there are discussions in terms of this, and the African Blue Economy Strategy has picked up on that. We need to start to look at that. We need to understand there's this whole idea of trying to meet the growing demand for minerals. We need to start to understand there's a possibility that this might just be a new frontier that we might benefit from, even as we get involved in all the research and development. And also they stressed, and this is really important because that's in line with the UNCLOS provision and the whole mandate of the ISA, that whatever we're doing with deep seabed mining, it must be done in a sustainable and environmentally responsible manner. And they recognize that there's a strong possibility of capacity building and knowledge transfer. Also, I've put this because, of course, the center is very, very much interested, or the key mandate of the center is in terms of the ECOWAS. The ECOWAS also has adopted a document, the ECOWAS Integrated Maritime Strategy, and I have the quote right on the slide. The thing about the strategy, this is my view, I think they could have gone a bit more in terms of talking about deep seabed mining. They obviously, and this is important, they talked about its potential environmental impact. But I thought they could have been more balanced in terms of putting this together, talking about the potential environmental impact, and also exploring and mentioning some of the potential benefits as well that might come from this whole idea of the deep seabed area beyond national jurisdiction, deep seabed mining activities. What are the potentials so that there's a balance? Because the idea of this is always to have a balanced approach to looking at it. One of the things, because we're going to be talking about the issue of sponsorship, whether it's strategic in terms of Africa not being part of this, or whether it's a missed opportunity, I thought to talk very briefly in terms of sponsorship. The way it works out is that there are a variety of entities that can carry out deep seabed mining activities in the area, whether by way of exploration or eventually exploitation. You can have state parties that would do it directly. They can enter into contracts with the International Seabed Authority. So you have, for instance, the government of India has done that, or they may have a state enterprise, or they may get a private entity that would go in. And in theory, it says even individuals can do that. But when it is not a state applied, if it's a state enterprise, a private entity, or in theory, an individual, there's the whole idea of sponsorship. Because the way it works out is that anyone that would go in there must be a state party of the UNCLOS. So if it's already a state that wants to go in, they're already a state party. But if it's a state enterprise, like if, let me give an example, if, for instance, NIMASA decides it wants to get involved in deep seabed mining activities, because it's a state enterprise, it would need to be sponsored by its national state. If a private corporation, like maybe an oil company or maybe another company interested in mineral exploration and exploitation wants to do that, they have to be sponsored by a state party to the convention. That's the way it works out. There was an advisory opinion of the International Tribunal for the Law of the Sea, the Seabed Chamber, on this whole issue of, seabed mining, the responsibilities and obligations of states with respect to activities in the area. And they pointed out that the notion of sponsorship is a very key aspect of this, because the idea is that if we have a state entity, that's easy, they're bound by the convention. But if we have a state enterprise, if we have a private entity or an individual, technically they cannot be parties to the convention. So when a state party to the convention sponsors them, that gives us that link so that those private entities, those state enterprise, can also be bound by the obligations under the UNCLOS. And what the ISA has done also is to adopt regulations that will govern all the entities that are involved in terms of this. So that's the whole idea of sponsorship. And the idea of it is to ensure that non-state parties that want to get involved are not just left hanging there. Somehow they're linked up to the state that will sponsor them. And through that, the state can actually monitor them to ensure that they carry out the obligations under the UNCLOS and the various regulations of the ISA. Okay. And the thing about it is that when a state sponsors an entity, the liability it has is not a strict liability, it's just a due diligence liability. It's required as a sponsoring an entity, the sponsoring state is required to just adopt the appropriate laws and regulations and take the necessary administrative measures under its legal system to ensure that those they are sponsoring carry out the obligation under the UNCLOS. And once they've done that, that is the extent of their obligation under the UNCLOS provisions. So let's go on to the regional groupings under the ISA. We have, in line with the United Nations, regional grouping, the ISA also adopts the same. You have the African Regional Group, you have the Asia Pacific Group, the Eastern European Group, the Latin American and Caribbean groups, the Western Europe European states, and others group. And when we look at these different regional groupings, guess what? Africa has the largest number of members in the ISA. All the other regional groupings have, some of them even such a huge number of exploration contracts. See Asia and Pacific. They have 17 contracts. The ISA basically has regulations and is currently doing exploration activities for 3 specific minerals: polymetallic nodules, polymetallic sulfides, and cobalt crusts. So Asian Pacific Group, there are various countries that have either had contracts with the ISA as state entities or as state enterprise, or they sponsored private entities even to enter into contract to carry out exploration activities. Eastern European Group also has a number 4. Latin American and Caribbean Group has 2. And then the Western European states and others group has 7. And then you have Africa having none. Some would say, well, maybe it's just because Africa doesn't have the technology or doesn't have the finance. But I beg to disagree, because in a minute we'll see even certain countries that have sponsored entities to have exploration contracts with the ISA that are nowhere near as blessed as Africa. They're not as big, they're not as financially able. They found ways in terms of trying to at least work with others so that they can connect and have the required technology. And we'll see why in a minute, because there's some benefits that they enjoy that Africa is missing out on. Why I've mentioned this Inter-Ocean Metallic Joint Organization is one of the contractors that has an exploration contract. But the interesting thing is that what they've done is to form a consortium. So even in applying for a contract for exploration and maybe eventually exploitation, a state doesn't need to, or a country doesn't need to do it alone. What these states have done, you have a whole range of them: Bulgaria, Cuba, Czech Republic, Poland, Russian Federation, and Slovakia. They've come together and they've had what we call multiple sponsorship of an entity. And if that's the way Africa wants to go, that is a possibility in terms of that. Let's look at some of the possible countries or states that have now sponsored entities. For instance, you have some Pacific Island states: Cook Islands, Kiribati, Tonga, Nauru. These are small island states, but they're sponsored entities because they're taking seriously the relevant provision of the UNCLOS. For instance, Article 148 of the UNCLOS says effective participation of developing states in activities in the area shall be promoted as provided for in Part 11. So what they've done is to work together and to try and work with entities that can fund, that can, provide the technology, and to get involved in terms of deep seabed mining exploration. Jamaica also has sponsored an entity also to have exploration contracts. So you have all these smaller nations who obviously know that there's a benefit in terms of being part of it. So the conspicuous absence right now in terms of the list of regional groupings that have exploration contracts with the ISA is that Africa has not sponsored one single entity to have an exploration contract with the ISA. In my view, I don't think it is strategic. And I would say why. I think we're losing out on an opportunity here. And the reasons I say that is that, first and foremost, if we're talking about being strategic, I would say a strategic position for Africa, especially because we produce a lot of the critical minerals in terms of our land territory. Normally what would happen if you have a business that is competing with your business, a strategic approach is to diversify, to ensure that you're not just isolating yourself because the competition might eventually have an edge. So if we're having this possibility of another competing industry, the deep seabed area beyond national jurisdiction, that will produce similar minerals, there's no reason why Africa should not be involved in this, taking advantage of the provisions of UNCLOS saying that there must be support for developing states, joining all the Pacific Island states, the Caribbean states who are involved and have sponsored entity, so that somehow we are continuing with producing our critical minerals on land, but also we're involved in the other business of the possibility of critical minerals being got from the area so that we have a win-win situation. I think that will be the strategic position to take. Another reason why I think Africa is missing out is that I don't think it's enough just to be at the table of any organization and just to listen to what is being said. I think it's important for the voice of Africa to be heard. And I'll explain what I mean. Right now in the ISA, there are a variety of ways by which the voice of different regional groupings can be heard. Of course, you can have your voice heard through state representatives, and that's why we have the ISA meetings, and we're constantly encouraging African states and African entities that are involved in terms of civil society, NGOs, to be part of the discussion. Right now, we're talking about the exploitation regulation. Africa needs to have an input. And to be fair, the African states, those who attend, have been giving their inputs, and we're expecting more of that because it's important, for instance, in talking about the critical minerals, how it to compete with the land-based critical minerals we have in Africa. There are provisions under the UNCLOS as modified by the agreement to ensure that land-based producers are protected. One of the ways is through an economic assistance fund. And it's important for Africa to constantly not just be at the table, but to be involved in the conversation, giving the African experience and also raising the African concerns. So, I mean, like through the African states representatives, we're seeing quite a few doing that. We're seeing also NGOs and civil society. And I'm very pleased. I mean, when I saw in terms of the Center for Community and Oceanic Law, thank you so much, Professor Amos. I think we need more of that. I think we have a few African NGOs and civil society, but I think we need more so that we can also feed in even our concerns in terms of the whole regime and even the different regulations that have been, developed. Also, you can have your voice heard even through the regional groupings. The African Regional Group has been very, very good. They have introduced a lot of things that have been picked up on by the ISA, which is good. I'm very fortunate. At one point, I used to be very involved in terms of giving legal advice to the African Regional Grouping, and I think they've done quite a lot. But I think the only challenge in terms of Africa that our voice is missing is in terms of contractors. The existing contractors that have exploration contracts have regular meetings arranged by the ISA. And contractors, as they meet, they also have their concerns, they have their views. Africa is not represented at those meetings because we don't have a contractor that has an exploration contract. So when they're discussing all that, Africa's voice cannot be heard. And I think that's a missed opportunity because I think in the whole range of opportunities the ISA provides, Africa needs to ensure that their voice is heard, they're putting forward African interests, and they're speaking, giving the African experience. Because with Africa, we have so much even experience in terms of even mining within our national jurisdiction that would really, really be very helpful. So missing out in terms of the contractors' meetings, I think it's a huge gap. And I think it's something that Africa needs to look at if we're to be as strategic as we need to be. because as long as we're not represented there on that table when contractors are discussing, there are certain things that other contractors will put forward that somehow it might be different if we had an African contractor even speaking on behalf of Africa. Also, I think we miss out in terms of not having a contractor, sponsoring a contractor, because we will not directly participate in deep seabed activities. Yes, we have trainees that are sent to go with contractors, but there's a limit to that. When Africa actually starts to get involved directly in exploration activities, there are capacities that we build up. And these capacities will not only be relevant for activities in the area, but also even for waters within national jurisdiction. Because whatever we learn from the area, it's not limited to only using it for that. The technology we pick up on, the knowledge we pick up on, we can bring that back to within national jurisdiction and help to build up all aspects of the blue economy. And I think we're missing out in terms of that. And then there are also some possible benefits that sponsoring states enjoy. The Pacific Island states, I mean, like, are enjoying that. As the sponsor an entity, usually what they do is they work with multinational corporations, just like we do for our oil industry. They come in, but the government is able to determine, okay, there are some revenues that will be paid to the government, taxes, royalties. They can insist that, okay, well, you need to employ a certain number of nationals, and that way they're training even their nationals. It encourages foreign investment. It even strengthens the domestic private sector, because it can be worked out that this multinational corporation will have to work with local players so that together they'll be sponsored even to get a contract with the ISA. Also, it provides different funding opportunities, even for it provides different funding opportunities for public service improvements and infrastructure developments. If taxes are increased, royalties are increased because these entities have to pay taxes, then it can be funneled into public service improvements. And we can even require, I know some of the Pacific Island states have that in their legislation, that these entities will set up a fund, and the fund will be directed towards doing different things, training, social corporate responsibility. And that can only be a win-win situation in my view. And it helps in terms of, sort of engaging with other aspects of the blue economy. For instance, with deep seabed mining, you need ships. You need to get ships out there. So Africa can pick up in terms of this and build up in terms of our shipping capacity. There's a lot of research done. As we're out there, we're building up on our research capacity. Even the processing of even the minerals that eventually will be got from there, we can, by our involvement with the African Free Trade continental area, we can start to think, do we need a processing facility that will deal not only with processing of critical minerals got from land territory, but also from the deep seabed area? I think there's a wide variety of opportunity. Again, I think we miss out because there's a prestige factor. With Africa being the only region not represented on the list, it's almost as if, what's going on? Why are smaller states able to sponsor entities to obtain contracts, and yet we have not? I think in terms of prestige, I don't think it really helps in terms of Africa. And I'll be rounding up in a minute. In 2017, we had a very major workshop. I was privileged to be part of that, organized by the ISA. And at that workshop, a whole range of important people from different parts of Africa came together. And we all agreed in terms of, that looking at the way things are, the other regional grouping, and the fact that Africa has not done anything yet, we all agreed that there was a need to do something. But for one reason or the other, it's almost as if that has been dragging on. There were a whole range of recommendations that were made. I was fortunate to also be involved in terms of that because I was acting as a consultant for UNECA, just encouraging African members to look at various ways that we can work together. It might be South-South cooperation. It might be getting a multinational corporation that would come, as we've been doing for other industries like the oil industries, oil and gas industry, and things like that. It might be a situation where we might need to come together, different African states, forming a consortium. And we know that it's important that we progress this as quickly as possible, because around the corner, exploitation just might happen very soon. And we don't want to be left in a situation where we're the only regional grouping that never sponsored an entity for exploration, and then we are struggling to catch up even for exploitation. If we want to see the technical study, I provided it, and I'll round up with this. We came up with a meeting in 2020 in Addis Ababa, and these are some strategic goals that we put in place that we might want to look at in terms of Africa, so we can speed in the process and actually get Africa on board. I think the strategic approach for Africa is to sponsor an entity to actually have a contract with the ISA for exploration. So I'll stop right there. Thank you so much for this opportunity. I'll be delighted to take any questions anyone has. Okay. All right. Okay, thank you so much. Thank you. Sorry if I've overshot the time. My apologies.
No, that's fine, Prof. It's an interesting discussion. Thank you, Prof.
So I don't know, are there any questions?
Thank you so much. Thank you very much. I'm extremely grateful for the very initial talk.
Okay, I think we have a network issue with Juliet. I can see Gomez's hand is up. We'll just hand you Yid for you to ask your question or make your comments. Comment, please.
Thank you so much to the organizers for this session, and many thanks to Prof. It's always great to hear from Prof. And I'm also happy this is coming back home to Nigeria. Yes. So I have a comment, more like a comment. Would you think the reason why some states have not been able to get an exploration contract, like I want to use Nigeria for example, because for Nigeria, I do know that some states up north, there are a bit of data now that there are critical minerals there, but then I also see the issue of national interest.
Okay.
So, like, if the government of the day is not focused on that aspect of mining, what can one do? Because if I look at the situation in Nigeria, for example, it seems the focus now is still on hydrocarbons. Okay. So no one is really taking the aspect of mining so serious. So could that be a reason why, we have been unable to get a contractor, for example, to go into exploration? And I am also happy to learn that we have an observer NGO that is attending the council sessions at the ISA. Thank you very much.
Well, thank you very much, Kame. It's always a pleasure to see you, and thank you very much for your contribution. I think the challenge that is being made is that the feeling is that it's either or. But I mean, like taking your example, okay, the focus is on hydrocarbons, but we know right now there's a push in terms of the world for states to go off fossil fuel type of energy. So I mean, like there's pressure in terms of that regard. Of course, we have to continue to tap in on that for as long as we can. But the challenge, I'm saying, is strategic approach, because it shouldn't be either or. It should be a situation where we're looking at the possibility of what are the various alternatives out there. Because there's no doubt, that I think is a question of time, in my view, because with the whole move in terms of exploitation regulations being developed, and there's an urgency to get that done, I don't think Africa will lose or Nigeria will lose if we continue with the hydrocarbon, but we work out. And as I said, there are a variety of ways we can do that. As the Caribbean countries, Jamaica has done that. We've seen the Pacific Islands. We can work together either through South-South cooperation, if we don't want to do it with multinational cooperation. India has a variety of contracts. Brazil at one point was a contractor until they found out that the part of the what they thought was the area was actually part of their extended continental shelf. You have, in terms of China, you have a whole range, South Korea, you have Singapore. So we can work with these nations once we're interested and say, look, let's form a consortium. If we want to do it alone with them, if we want to work together with African states, we can do that. Because I think even in normal business, if you see that there's a competing industry that is about to, come forth, we might have no control in terms of stopping it. I think it's strategic to say, well, we will continue with our business, but we want to also invest in the other business and get involved so that whichever way we don't lose out. If the activities of exploitation in the deep Seabed area carries on full blown, we're involved in terms of that. So we'll still be getting returns, not just as beneficiaries, but actual participants in the business. And if at the end of the day, hydrocarbon, they're saying they're giving us time, we can do it parallelly with that. So I'm just saying, I think it's a question of African states just getting together and saying that from all indications, what they're worried about, maybe in terms of not having the finance or the technology, there are various ways that all these other states have worked that out. And Africa can learn from the states and get on board. And the ISA is just waiting, because of the provisions of Article 148 to encourage any developing state that is interested. They provide the support, they provide advice, they provide encouragement. So we have an opportunity based on what we have there to step forward and get on with it. And I think we can do it.
Thank you, Prof. So just to go further, please. So I just got back from the 31st, the part one of the 31st session of Council. Yeah. And I see from the African group, some member states actually are tilting towards the enterprise. That the enterprise is the way, one of the ways in which developing states like Africans can participate in deep sea mining. So I kind of see that, okay, really some states may not want to just go into that, but go through the enterprise. Can you make a comment on that, especially for the reserved areas?
Right.
Yeah.
Okay, thank you very much, Kume. That's right. The enterprise is one of the ways. But the thing about the enterprise is that the enterprise for a while will be part of the secretariat and will not be able to, basically go into exploration until it gets a joint venture partner that has the requisite technology and finance. And the challenge with that is that while the enterprise might be a way, and we don't discountenance that, it's something that probably will happen in the future. I'm saying that right now, Africa has the opportunity to negotiate even with technical partners out there to say, well, we want to start off now and get an exploration contract. And when the enterprise starts functioning, it doesn't stop Africa from still going ahead. Some of the countries that are state parties to the UNCLOS, some of them have 3, 4 exploration contracts. So I'm just saying we don't need to wait until then. We can start off and try and get an exploration contract now. And then when eventually the enterprise starts functioning, that might be another platform that will get an additional exploration contract.
Thank you, Prof.
Thank you very much.
Thank you. Thank you. Is there another question? I have a few questions, but I would like to hear from others first. I know our time is fast spent. Maybe I should just ask my questions first.
Sorry, Professor Amos, I think there's a Mobology Ezekiel who has turned up that I can see.
Professor Ezekiel, please. Professor Ezekiel, are you there? Okay, please just speak when you're ready so that we don't waste time. So, Prof, I'll start with a comment to thank you very much for your time this afternoon. And we are happy to know that you came back home and Faculty of Law, University of Benin is doing something, because it's not something that is much spoken about in Nigeria. And I'm glad that Faculty of Law, University of Benin is taking up this challenge,
Hello.
Yeah, okay. Yeah, Professor Ezekiel, please.
Okay, thank you so much, Professor Nablili. Thank you so much, Prof. Again, God bless you. And my concern is that African countries may have their fears. I want to find out, is it the right to contractors for exploration? Do they get rights, automatic rights for exploitation? Because we know that under oil and gas law in Nigeria, for example, is not an automatic right.
Yeah.
That you have a license for exploration does not mean you have a license for exploration.
That's a good point. Yeah. Yeah, that's a very good point, because what happens is that you have the exploration stage and then the exploitation stage. What normally would happen with the exploration is that you obviously have to start to prepare the grounds, do all the necessary research, put together the necessary baselines, and eventually, once you've done that, because a contract for exploration is for a period of time. If, of course, I mean, like you've shown that you've done something in terms of gathering all the necessary thing, and of course, determining that the site you have obviously done some research is something you want to progress to the exploitation stage, then yes, you can do that. But the thing is, just like with any other, mining activities, just like with us saying, with oil and gas, for instance, which I happen to be familiar with in terms of Nigeria, that, well, because we're not sure we'll get to exploitation, what if after we finish, we don't have commercial quantities, then we don't bother to do so. I think that would affect in terms of business, because business is all about before you go ahead. And that's part of the thing why we have to work with technical partners for the exploration. The technical partners will be able to advise, give us an idea of what are the possible areas that we can look towards. And one of the very excellent thing about developing states is that under the UNCLOS, what is required is that any developed state that applies for exploration, they have to apply for a site that is big enough to take to exploration activity. So what will happen is that those developed states will do all the groundwork. And when they've done it and they find a big area that they feel, oh, this has huge potential, very likely that we can go to exploitation, the UNCLOS requires them to divide it into two. That's what is called the parallel system. So one aspect they take and they continue what they need to do. The other aspect they bank. It becomes what we call a reserved area. So for African states who are obviously developing states, if you apply for a contract of exploration, you'll be applying from one of those reserved areas that the developed companies have already looked at, and even they've, from all indications, the reason they will go on with it is because they know that it has commercial potential. So the way it works out, I think that helps in terms of minimizing the risk for African states when they get exploration contract, and the danger that eventually, okay, well, there's nothing, because a developed state would have done that background check. And of course, they will not go on if they feel there's nothing. So if they give it a go ahead and they take their own site, then it's very likely that there's something there for developing states like Africa to get involved in. That's what the Caribbean states are doing. That's what the Pacific Island states are doing. And that's why some of these multinational corporations actually prefer to go through developing states, because it minimizes the amount of work they would do in terms of exploration.
Thank you so much, sir.
Thank you, Prof.
Okay.
We have a question on the Professor Ezike, are you done?
Yeah, no, I have one more question, please.
Okay, please go ahead.
With this teaching and this seminar today, we are so ignited to do something for about protecting the interests of Africa. But as academician, what can we do? I don't have money for the intensive, the capital intensive nature of the contracts. Yep. So what can we do? What can we help out?
Oh, that's a fantastic question. I think one way we can help out is in terms of advocacy. I know academics have a lot of voice because we're recognized as having done research, having an understanding. So I think we can start to get in touch with our contacts who are involved in relevant industries, who are involved in terms of relevant ministry. For instance, we have the Ministry of the Blue Economy. We can start to have conversations with them, trying to do presentations in terms of this, trying to explain what it's all about. We can use our contacts, maybe in the presidency, trying to talk about it. And when we as academics are talking about it, people want to listen, and then we can explain what it's all about, and then they can go and do their further research and find out that it's not as difficult as they think it is. Because others have gone ahead and they've been able to do it. And there's no reason why we cannot. Especially even in Africa, we have, for instance, with Africa, in terms of those who have been trained under the contractors training, the largest number is from Africa. So we have a lot of people who have been trained, who understand these things, and we can call on them even to help as we move on to apply for an exploration contract.
Okay, sir. Thank you so much.
Thank you very much, Prof.
There's a question, the chat group. It said, you mentioned the UNCLOS providing for exploitation being done in environmentally responsible manner.
Sorry, I don't know, I can't seem to hear for one reason or the other.
Oh, can you hear me now?
Yes, I can hear you now.
Yeah, I was saying that there's a question in the chat group. It says, you mentioned the UNCLOS providing for exploitation being done in environmentally responsible manner.
Yeah.
And I'm wondering to what extent, that's a question, are there measurements set, or is it something that will be done in future? Then there are two questions. The other one is talking about NEMESA. Another aspect is the role of NEMESA in this. Is this what the Deep Blue project is about?
All right. Okay. Thank you very much, Prof. For the environmentally responsible manner, that's a mandate of the ISA, as I said. So as they are preparing all their regulations, all the documents, they are taking to consideration the issue of putting in place mechanisms that would ensure that contractors that go in do it in an environmentally responsible manner. One of the things we do as the Legal and Technical Commission is that every contractor has to send in a report, an annual report. And we look through the annual report. We have environmentalists who are in the Legal and Technical Commission. We have geologists, we have biologists. So if there's anything in the report that gives an indication that there might be a challenge, then we require the contractor to give us more information. And if there's a problem, the ISA can issue what we call an emergency order to stop them from going on. And a good thing also about the ISA, because some might say, okay, well, maybe the LTC might not have all the information, is that with the whole process of having the observer status, we have NGOs who are deep into environmental matters, who, if they get any information, are able to bring it out during the council meeting. So in response to your question, the environmental measures are not left till later on. But because it's a mandate of the ISA, we're looking at that as we go on. The ISA is looking at that as we go on. The LTC looks at that as we go on. One of the things, I won't be able to go into too much details on that, but if you go on the ISA website, one of the things that the LTC is working on is what we call regional environmental management programs. Right. And the whole idea of this is to ensure that when there's exploration and exploitation, there's a mechanism to ensure that somehow there's a way to monitor to ensure that this doesn't lead to irreparable environmental damage. Okay, I hope that helps. Another aspect is the role of the NEMESA in this. I'm afraid I don't know much about the Deep Blue project, but I would say, just as I responded to Professor Mobolaji's question, is what going and finding out, is this connected to deep seabed mining? I know at one point NEMESA had on their website that they basically they talked about deep seabed mining. So is what finding out, is this project connected? Is there a way, if it's not, that we can make it connected? And if we need support, as I said, there are a whole range of people who are able to give support, even people from Africa. I know geologists, I know biologists who are from Africa, and of course the legal people who are just waiting to be called to support any state interested in sponsoring. And they'll be there to assist in terms of that.
Thank you, Prof. I don't think there's any other question. I will just make my quick comments and hand over to Professor Bazoaye for the vote of thanks. Yeah, and I was going to mention the side bank because I saw that because of time, you didn't go back. Thankfully, you have answered that with Professor, while we're dealing with Professor Ezekiel's question. And also talking about advocacy, I think that's very important, and knowledge in this field. We've had Oliver Ganisakari, the CEO of Impossible Mentor, on this platform. They just sponsored, that the latest company to sponsor activity in the area, Bahrain. Well, so I think it's not the cost, because it's the contractors that bear the cost, not even the states. Exactly. So that's something that Africa should consider. Now, I have two questions. One is, do you think because we've seen the slow pace of negotiation of the mining code, do you think that will not get complicated with the BBNJ? Because you have a lot of a few state parties to the BBNJ at the moment, and the matter, I'm sure you are aware of the decision that the Secretary General wanted the council to take, that council didn't take eventually. So do you think, do you not think there will be some complications?
Thank you very much, Professor Emas. That was a very interesting point. But the thing we have to be careful about, I don't think there's any tension or conflict between the BBNJ and the responsibility of the ISA. Because if we look at the BBNJ agreement, I think it's Article 5. The BBNJ agreement is very clear that even the whole process of the BBNJ cannot ignore existing institutions, frameworks, and and all that. So it also talks about the fact that the whole process, because when we look at the BBNJ agreement, it defines the area beyond national jurisdiction as including the area under the ISA and the high seas.
I see.
But it also says that everything has to be cooperative. So the whole idea, and that's why the ISA will be involved and has been involved in terms of the BBNJ discussions, and will continue to do so, so that they can put forward their wealth of experience before the institutions of the BBNJ. And then the BBNJ, because it's a more contemporary agreement, can also, work with the ISA in terms of what are ways that, things can be improved in terms of maybe like issues like environmental impact assessment, things like that. So there's not meant to, the two arrangements are not meant to have a tension. They're meant to work together because the BBNJ was brought in to fill in a gap. Remember, the ISA was set up to deal with mineral-related matters. The BBNJ is not dealing with mineral-related matters, but it's dealing with marine genetic resources, for instance, and other issues like that. So what would happen, I don't think it would delay the process of the exploitation regulation, but what will happen is that the ISA and eventually all the BBNJ institutions, when they're set up, would cooperate and work together. And there's nothing unusual about that, because in terms of international law, there's what we call regime interaction, as you will know. Sometimes you have different regimes interacting and they have to work together. For instance, with the ISA also has to work together with the IMO, because ships will be used in terms of it. So what these bodies usually would do is they work amongst themselves in memorandum of understanding, and they share expertise, they share knowledge, and it can only get better for the two sides as they learn from each other.
Okay, just my concern is, there are two sides to it. The very environmentally conscious part to this thing. I'm just thinking that may become a weapon that will tick, that will shift the pendulum towards that side of the argument, because we are talking about biodiversity, we are talking about mining. There's always that interaction, environmental interaction that comes into play.
That's right. But the thing about it is, let's remember with the ISA has a mandate on the UNCLOS. The BBNJ agreement is an implementing agreement on the UNCLOS. So the BBNJ agreement, the intention is not for it to come and undermine the ISA. Neither is the ISA to undermine, So it's just to arrive at, for instance, the ISA, as I said earlier on, the ISA is not just going to allow, states like Wild West to go in there, or contractors, and create damage, because his mandate is to ensure that the marine environment is protected. So if we can learn from the BBNJ, because it's a more contemporary agreement, there's been development in terms of environmental protection, then it learns from the BBNJ institution, but also because it has had vast experience. The contractors that are doing exploration, they have vast experience, even in terms of environmental, the species in the area. And the ISA has various databases that has all these species that have been reported by. So it will only help everybody. I think it will be a win-win situation as they work together.
Thank you. My last question before I hand over to Professor Bazoye. I was just thinking if we could come home a little bit. We've got, can you hear me?
Yeah, I think please, if you can repeat it again. Yeah.
I don't know what's happening with but can you hear me?
Yes, I can hear you now.
Yeah, I was saying, I don't know if we can come home a little bit. You know, Nigeria has got an extended continental shelf because you mentioned about Brazil, that didn't know it was part of their continental shelf. But some of these, can you speak to the possibility? Can you speak to what we can do or what Nigeria can do with its extended continental shelf?
Oh, yeah. Okay. Okay. Thank you very much. I think that's a very important question. First, I want to emphasize the extended continental shelf is not part of the area. It's part of whatever coastal state has that. And you find out that with the extended continental shelf, Nigeria has been very fortunate. We made a submission to the United Nations Commission on the outer limits of the continental shelf. They accepted our submission. So basically, they made a recommendation. So what has simply happened is that Nigeria's continental shelf has, just like the work, extended beyond what we normally would have had. So normally we would have 200 nautical miles, but as we've successfully submitted, we now have beyond that. And all that extension basically will have huge resources, minerals, you know, non-living resources, living resources, and you name it. So that's the point I was trying to make in terms of, you know, if we get involved in exploration contract, even in the area, whatever capacity technology we learn from, we can also bring it back, not only to the extended continental shelf, the whole continental shelf, and even do more to develop even our continental shelf. So I think the thing is that with the extension, Nigeria has potential of more resources in the continental shelf that it will have to look towards and see what can be done in terms of, you know, building up on the blue economy, even by looking at that.
Thank you, Prof. Congratulations once again on your recent election as the Vice Chair of the LTC. Thank you so much. I think this may be your first public engagement after that, so we are fortunate. Professor Bazoye, please, if you give me vote of thanks. Thank you.
Thank you, Prof.
Thank you very much, Professor Nabulele. And let me also join Professor Nabulele to congratulate you.
Thank you.
Since this is your first outing, we are proud of you. You are a product of Thank you very much for that illuminating presentation.
Thank you.
So much has been said, and even from this end, I almost had a missed opportunity. Perhaps maybe I should have taken a cue from the need to have a technical partner, particularly when it comes to putting in place what I actually needed so that I can seamlessly participate, you know, as it were. But that point has been firmly made, you know, concerning what we need to do from this end, particularly with respect to participating, you know, as it were, even though we have capacity issues. So thank you for the presentation and also for the organizers too. The Center for Community and Oceanic Law, we are very happy that we have this partnership with the Faculty of Law, and we hope to continue to key into these arrangements so that we can have more cross-fertilization of ideas. And for the participants online too, our professors, our colleagues, thank you for joining, and we've all been richly blessed this afternoon. I must return again to Professor Edwin Egede. You've shown that your forte is actually this area, and you've been able to transverse, even though the time is limited, but you have richly educated us with respect to the potentials as far as this area is concerned. And for those who work behind the scene to ensure that we've been able to have this webinar, many thanks to you all. Once again, the only thing that one can say, and which all of us have continued to say by way of our applauses, is to thank you, Professor Edwin Egede. Thank you, and thank you.
Yeah, thank you. Really appreciate that.
Thank
And please,
you.
if there's anything I can do, as I've said, UNIBEN Faculty of Law is very close to my heart, and I want to thank the Faculty of Law for the investment. And I must say, beyond even the professional, I want to thank the Faculty of Law for giving me my wife, because we met at the Faculty of Law. So thank you very much.
That's a good one.
Thank you, Prof. And thank you. I will add my personal appreciation as well to that of Professor Bazua, who incidentally taught me international law. So please, yeah, he's my teacher. So he taught me international law, and he's been very supportive over the years. So I want to say thank you to everybody. And Professor Egede, I'm so grateful to you. Thank you so very much. God bless you.
Okay.
Bye-bye.